afternoon and welcome to today's webinar organized by Aperio Intelligence. My name is Veronika Konieczna and I lead Aperio's Russia and Eastern Europe team, which supports all of Aperio's service lines, including due diligence, investigations, ESG, and strategic intelligence. The topic of today's webinar is the impact of unexplained wealth orders on the UK's financial and property sectors, and I'm very happy to welcome an excellent panel of experts whom I'll introduce shortly. The UWO is an investigative tool which has been available to UK authorities since January 2018. It can be used primarily against politically exposed persons from outside the European Economic Area, or in cases when there are reasonable grounds to suspect that an individual is or has been involved in serious crime. The UWO was, of course, introduced to help tackle the influx of dirty money into the UK, and it was met with great enthusiasm, both by the general public and by the media in the UK. But it is important to remember that the UWO is just one of several investigative tools available to UK authorities, and as far as we know, it has only been used several times since it was introduced. So perhaps the expectations created by the initial enthusiasm were a bit too high, and it is clear that the UK still has a lot of work to do to be able to successfully tackle money laundering in the UK. So today our panel will discuss this topic and offer their predictions for the next few years, but also reflect on all the implications that these AML initiatives have on the UK's financial and property sectors. Our first speaker will be Roman Borisovic, who is a former investment banking and insurance executive and currently an anti-corruption campaigner. In 2015, Roman appeared in the Channel 4 documentary From Russia with Cash, which focused on money laundering in London's property sector. After that, he set up his own anti-corruption initiative called Clamp K, which, amongst other things, organised the London kleptocracy tours, which supported their anti-money laundering campaigns more generally. Roman is also an ACAMS certified AML specialist. Our second guest is Anna Bradshaw, who is a partner at Peters & Peters. Anna advises clients on all aspects of financial crime risks and sanctions risks, compliance and enforcement. She also assists with investigations into suspected breaches and related reporting obligations, and represents suspects and witnesses in contentious proceedings. Anna is an associate fellow at the Royal United Services Institute and works on research into the design and implementation of sanctions by the US, the EU, and the UK. Anna also holds a doctorate in anti-money laundering regulation. And last but not least, joining us today is Nathan Brooker, who is a Financial Times journalist who writes about the UK and international property markets. He joined the FT in 2015 and is now editor of House and Home, and has written also about money laundering in the UK's property sector. So just before we start, a couple of housekeeping points. That we will begin with the free presentations and follow up with the Q&A session. Please do start sending your questions for the Q&A session during the presentation, and you can use the Zoom Q&A function to submit your questions, and we will try to address as many of those as possible. And just to let you know, this webinar is being recorded so that we can share the recording with those who were not able to join us today. So I think we can start. Perhaps, Roman, we can start with you. If you could tell us about your experience with campaigning against money laundering in the UK, and also give us a bit more background about the UWOs and other AML initiatives which we have seen in the UK so far.
Thank you very much, Veronica, and good afternoon, ladies and gentlemen. Let me start with the history here. In 2010-2011, then anti-corruption blogger Alexei Navalny, now unfortunately the jailed leader of the Russian anti-Putin opposition, exposed luxurious properties in France, Spain, and the UK, and the US, owned by the Russian kleptocrats. At that time in Russian history, which seems quite liberal now, when Navalny's investigations led to resignations and fueled public curiosity, I became interested in a slightly different question. Why has he never exposed anyone in the UK? Surely all those governors and MPs and deputies and ministers had, if not castles in Scotland or manors in Surrey, then at least pieds-à-terres in Mayfair enjoyed by their mistresses or children. Navalny's answer was simple. They use anonymous offshore companies. We cannot establish and prove the ownership of those. Indeed, having come back from Moscow to London in 2013, I discovered that the avalanche of dirty money coming to the UK from global plutocracies was using offshore corporate structures to hide ownership and the origin of funds. So we started preparing our political campaign against it. Transparency International counted properties owned by companies based in all sorts of exotic destinations. Global Witness investigated some outrageous kleptocratic property empires. And I worked with, as Veronica said, Channel 4 on a documentary called From Russia with Cash. In the process of making this film, we told 5 senior estate agents in London that a Russian minister who embezzled money from his government wants to buy their properties with his dirty cash. 5 of the 5 had the same recommendation to the corrupt official: set up an offshore company and we would gladly transact with you via this corporate shell. With Transparency International research showing the number of UK properties owned by secretive offshore companies at 91,248 and counting, it became clear that to stop dirty money from flowing into the UK, we needed transparency, accountability, and recourse to the assets. Transparency to be able to identify the beneficiaries of these assets, accountability so that their corrupt owners can be prosecuted, and recourse so that the assets acquired with the proceeds of crime to be confiscated. These are the goals of our campaign to amend the UK legislation and the conditions necessary to clean up the UK real estate. Interestingly enough, the legislative machinery chose to start with the last item on the agenda. The idea of foreign companies register for entities that hold assets or do business in the UK was introduced as soon as we started our campaign in 2015. Soon, the government announced consultations and the draft registration of overseas entities bill was tabled in 2016. The purpose of this law is to make public the beneficial ownership of offshore companies in the same manner as Companies House publishes information on PSC, persons with significant control, of UK companies. However, exactly at the same time, there was another bill already in the making, the Criminal Finances Bill, and it was decided to tackle it first. This is how the Unexplained Wealth Orders made it into the UK legislation. The idea was sponsored by the National Crime Agency and was very much supported by Sir Eric Pickles, at the time the anti-corruption champion of David Cameron's cabinet. Our NGO approved the concept and with all the features of the orders. The only thing we, unfortunately unsuccessfully, argued for was the inclusion of civil society and media into the list of potential applicants for the UWOs. In the end, the list was restricted to the law enforcement only: the National Crime Agency, Her Majesty Revenue and Customs, the Financial Conduct Authority, the Director of the Serious Fraud Office, or the Director of Public Prosecution. Thus, Unexplained Wealth Orders, civil recovery instruments, were legislated ahead of the laws on transparency and accountability, which unfortunately very much limits the use of these otherwise very efficient instruments. The UWOs can be only instigate against people, not companies or trusts, and not against their directors or trustees. This means that the ownership of the offshore corporations, which hold the UK assets, must be linked to an individual, who must be then connected to either politically exposed persons or organized crime figures, and not linked by a dotted line on some diagram of kleptocrats' offshore holdings published by the likes of Navalny. The proof must be acceptable in the UK court of law. So this is the first and largest flaw of the current legislation: the inability to reveal the beneficiaries of offshore companies. This allows the UK enforcement to challenge most outrageous instances of money laundering, all 90,000 of them in Transparency International's count. The other weak point of the current legislation in relationship to UWOs is that the reasonable grounds for suspecting that the person's known source of lawfully obtained income are not sufficient to enable them to obtain the relevant assets. These grounds can be easily shattered if such person is a politically exposed person in a kleptocratic regime. Let's take the ex-Russian Deputy Prime Minister Igor Shuvalov, for example. His offshore dealings with Russian oligarchs leaked by his ex-lawyer have been widely publicized. On the basis of the documents published, A UK judge would have charged the UK government officials involved in similar dealings with bribery, corruption, conflict of interest, extortion, abuse of office, and many other crimes. However, Mr. Shuvalov's Kremlin-based employer argues that the dealings are totally in line with the Russian law. Moreover, Mr. Shuvalov paid all the taxes due in Russia, obviously, on his arguably illegal gains. The UK court would be powerless to contest such statements, and the application of an order would have been declined. Luckily, there is new Magnitsky legislation in the UK. Along with Bill Browder, we campaigned for a UK Magnitsky Act, which would enable the government to sanction foreign criminals, including freezes of assets and visa and travel restrictions. Our advisory board chairwoman, Margaret Hodge, was one of the co-sponsors of Magnitsky Amendment to the Sanctions and Antimoney Laundering Act of 2018. Initially, the amendment was aimed solely at human rights abusers. However, very recently, it was extended to cover corruption. On the 26th of April this year, the UK government sanctioned first 22 persons on the grounds of serious corruption. This plugs in the hole in the legislation, but we would still argue that the extension of the UWOs regime to cover corruption would make the orders more robust. Which brings us back to the transparency issue. The Overseas Entities Register Bill has gone through 2 series of consultations, joint committee scrutiny, and is totally ready to be passed. Brexit and COVID have been pushing it to the back burner of the Parliament for 2 years now. We need this law urgently to complete the legislation cycle. Hopefully, we will see it receiving royal assent this year, which would take our campaign to the next step, from changing the legislation to demanding enforcement. The enforcement will have to be carried out by the law enforcement bodies in 3 different segments. Data collection would need to submit it on time true identities of the ultimate beneficiary owners. Second, HMRC, as the regulator responsible for the AML activities in the property sector, would need to identify politically exposed persons among the UBOs and check the values of the assets against their stated income. And third, FCA would need to make sure that banks and other financial institutions handling accounts and payments of these offshore companies have done their AML checks on the UBOs and prosecute the banks if they fail to do so. Clearly, items 1 and 2 will require some lag time, 18 months as envisaged by the current draft law to produce the data on the UBOs. In the meantime, it will be the banks who will have to use this time to make sure that they have the correct information on the UBOs and worry about any regulatory or legal consequences when the UBO IDs will be made public. The FCA would need to make sure that in this time, the lead time to the act coming into force, the financial institutions pay maximum attention to any changes or discrepancies in their data on the UBOs of these offshore companies and flag any suspicious activity. Maybe it would be worth at this time to have another screening from Russia with cash to remind the bankers that according to the UK law, there are only 2 actions not reporting which carries criminal responsibility for the persons in possession of information. That is terrorism and money laundering. Well, that's pretty much it on my side. Thank you for your attention.
Thank you very much, Roman, for the excellent overview. And I'm really glad that you mentioned the recent UK sanctions as well. I think that's probably a topic we might come back to a bit later. I also think that another screening of your documentary is not a bad idea, definitely. Anna, could you perhaps tell us a bit more about the UWOs from a lawyer's perspective and maybe sort of reflect on what we have learned from the cases we have seen so far and perhaps offer some predictions for the next few years and what will come next?
Sure. And thank you. Why have we seen so few UWOs being applied for? Does it mean that there's something wrong with this power that needs to be addressed? This is the question that many are asking themselves, because on the face of it, they should be used more. Firstly, a number of enforcement agencies can use these powers. The NCA, of course, has pursued the 5 UWOs that we know about to date. But they can also be sought by HMRC, the FCA, the SFO, and the Director of Public Prosecutions. And secondly, the range of potential respondents to a UWO is potentially very broad indeed, provided, of course, that you can persuade the High Court, firstly, that property worth more than 50,000 is held by someone who's either a non-UK, non-EEA PEP, or a family member or known close associate of such a person, or that there are reasonable grounds for suspecting that they are or have been involved in serious crime. Secondly, and this is perhaps the more difficult hurdle, you need to persuade the High Court that there are reasonable grounds to suspect that the known sources of their lawfully obtained income would have been insufficient for them to acquire the property. But provided those small tests are satisfied, you can seek a UWO against anyone who's connected to such persons. So have the legal challenges dampened the appetite for UWOs? As I said, the 5 reported cases so far are considerably lower than the government's expectations, and the impact assessment that accompanied the introduction of the new regime, they thought we would see 20 UWOs a year. The temptation is to interpret this as a sign that something is wrong, and particularly when you compare it to the much more enthusiastic use that has been made of similar powers that were introduced at the same time, notably the account freezing order power. And although there have been setbacks, and although the costs of pursuing unsuccessful UWOs can be very high when the enforcement authority is ordered to pay the other side's costs, or potentially also compensation for any damage caused in the interim period by an interim freezing order, I don't think that legal action is the explanation here. I think the better explanation is that it's simply not appropriate to apply for UWOs in many, and perhaps not most, civil recovery investigations. And the reason for this is that, as has already been pointed out helpfully, it's an investigatory tool, and it's intended to facilitate, to support the already existing power to recover through civil proceedings property obtained through unlawful conduct. Focusing on the low number of UWOs doesn't mean that those civil recovery proceedings aren't being pursued successfully with the assistance of other investigatory powers, including more conventional disclosure orders, or that unlawfully obtained property is not recovered using other tools, such as confiscation following conviction, or I mentioned the account freezing orders, and there are other related seizure and forfeiture powers. You would expect a UWO to be applied for a relatively early stage in an investigation, and at that delicate, sensitive time, you may well want to avoid the publicity that potentially accompanies an application for a UWO, particularly if they're challenged. And that could also involve a significant diversion of resources. So is it worth even having them? Why were they introduced in the first place? Well, clearly, if they're deployed at the right time in the right investigation, they could potentially yield great results. And that's their reason for being. The information that you're expected to receive in response to a UWO is highly likely to be accurate and reliable, given that it's a criminal offence, punishable by up to 2 years, to knowingly or recklessly provide a statement that is false or misleading in a material particular. And as I mentioned, there are interim freezing orders that can be applied for at the same time that prevent the dissipation of the property that you would want to remain available for a future civil recovery order. But perhaps the most helpful aspect of UWOs is that if there is no response at all, the burden of proof is reversed, and there is a presumption that the property has been obtained through unlawful conduct unless proved otherwise. But the bar is quite low here, and purported compliance, even if it's not full compliance, is enough to make that presumption inoperable. And there's also no real legal test as such for assessing the reasonableness of an excuse for failing to comply. But above all, I think that introducing UWOs had a symbolic significance because it signals the UK's commitment to asset recovery. And that's a purpose in itself. I wouldn't go so far as to say that it's had a deterrent effect on people who wish to park their unlawfully obtained gains in the UK. This would be impossible to measure in any event. And speaking from experience, it has clearly and very predictably had a chilling effect on people's willingness to do business, particularly with PEPs, but also with anyone else that is subject to adverse media, not just in the regulated sector. And this is problematic for exactly the same reason that overcompliance in the anti-money laundering and counter-terrorist financing context is problematic. It leads to de-risking. Do I see any room for improvement to the power? Yes, of course. It was at one stage proposed that there should be a restriction on the ability to fund legal challenges to UWOs. And just to be clear, I am not an advocate of that. In my mind, it would be one sure way of undermining the perceived legitimacy of this power, given that it already departs quite dramatically from procedural rights by reversing the burden of proof. But one obvious way to strengthen the power is by expanding the definition of a PEP to include domestic PEPs and EEA PEPs. But as far as I'm aware, this is not on the table, query why. It would also make sense, in my mind, to dovetail the power more closely with the UK's new global human rights and anti-corruption sanctions. And there is already quite an interesting overlap, which I'm not sure has been explored in advance, or whether anyone is considering exploring it more fully. I'd be very interested in monitoring this. Civil recovery proceedings can already be brought against property which represents property obtained through conduct that is illegal anywhere in the world. But it includes, following an amendment much earlier than the Criminal Finances Bill, conduct which is connected with the commission of gross human rights abuses or violations, provided 3 conditions are met. And those 3 conditions, in a nutshell, require the conduct to be connected to torture or cruel, inhuman, or degrading treatment or punishment by someone who seeks to expose illegal activity by a public official or someone acting in a public capacity. And this is a much narrower test than the grounds that you can be designated for under the new global human rights regime. But you could potentially see a designation that is sufficiently aligned to that test to mean that the sanctions designation could be relied on as a reason for seeking a civil recovery order. And that potential is much broader, obviously, under the new corruption sanctions, because the definition of corruption for those purposes, meaning bribery or misappropriation of property involving a foreign public official, would clearly be serious crime for the purposes of both UWO and a civil recovery order. I'm very conscious of time here, so I think, Veronica, I haven't monitored, but I I'm happy to pick up on the Brexit point a little later, but perhaps I should hand over at this stage.
Okay, great, thanks very much. And I think, well, thanks very much for explaining the sort of technical details behind the UWOs, because it's not as simple as it sometimes might look, especially from the media. And it's I find it quite interesting how much media attention they have received since they were first introduced, and that is positive on the one hand, because it means that the general public is more interested, but at the same time it probably puts a lot of pressure on the authorities to actually use them more often, when in many cases, as you said, it's not the most appropriate tool to use. And as I said, it's not as simple as it sometimes might look. So I think you have touched upon a lot of very interesting topics in your presentation, and we'll probably come back to some of those in the Q&A. So please do keep sending your questions through the Q&A function, so that we can get back to those topics that are interesting to you during the Q&A session. Now, Nathan, of course, prime real estate has been at the center of the high-profile UWO cases so far, and real estate is one of the sort of most popular and I suppose effective ways to launder money. So property and London property is quite often mentioned in relation to money laundering. So how what are the effects that you have seen of these AML initiatives on the property sector, and how is the sector having to adjust to these new regulations?
Well, thank you, Veronica, and good afternoon, everyone. So the sector is adjusting. Anti-money laundering regulations have tightened considerably in the last 15 years. But I just want to give the audience a little background on how important this subject is to our readers. One of the core subject areas that we cover on House and Home section is the luxury property market in what is often called prime central London. These areas have a lot of overseas buyers, a lot of properties owned through offshore companies, and when it comes to accusations of suspicious wealth, criminality, and money laundering, a bad reputation. For that, you can just ask our readers. Stories on prime central London get a lot of engagement, a lot of reads, a lot of shares, and a lot of fiery comments. Under a story we published just yesterday on why have UK house prices not tanked during the pandemic, it took a reader 6 minutes to post a link to the Wikipedia page on money laundering, and then wrote underneath, "I rest my case." So money laundering is something our readers care very strongly about, and with good reason. Transparency International have identified, I think it's £5.5 billion worth of properties in the UK that have been bought with what they consider to be suspicious wealth. I was talking to a financial crime expert the other day who thinks that true figure is, double that, and add a couple of extra billion on for good measure. But what effect is it having on the property market, on prices, on transactions and affordability? Well, that's pretty difficult to say. What we do know, and to get back to your initial question, is that AML regulation in this country is a lot more robust than it was. Since 2007, estate agents have been required to carry out know your client checks and enhanced due diligence on buyers deemed to be higher risk. That's anyone with links to criminality or people connected to foreign or other enterprises. They're called politically exposed persons, as Anna was saying, PEPs. These are all part of the EU's third anti-money laundering directive, and since then we've had the fourth and the fifth. They've all been carried over to UK law, despite the fact that we've now left the European Union. From 2017, estate agents have had to vet not only their clients, which are the people selling the property, but also their customer, which is the person buying the property. Agents have had to ascertain the beneficial owners of any companies or trusts involved in a purchase too. And last year, this was extended to anyone letting a property for more than €10,000 per month. And that applies to both the landlord and the tenant. And if they do suspect any money laundering, as part of the Proceeds of Crime Act 2002, estate agents are required to submit what are called suspicious activity reports, or SARs, to the National Crime Agency. The question is, how have estate agents been coping with these new regulations? Well, the consensus is not brilliantly. Looking at SARS in particular, in the last financial year that we have data for, which is 2019 and 20, the NCA received more than 573,000 suspicious activity reports. Banks submitted 432,000 of those, and estate agents submitted 861. Which, to their credit, was at least 200 more than they managed in the previous financial year. But the low number may not even be the most pressing concern. For some of the people I've spoken to, it's the low quality of the reporting. For several years across all sectors, low quality reports have been blamed for swamping the system, and this is certainly true of the property sector. Back in January last year, I went to a training day for estate agents hosted by a former police detective called Jerry Waters. He now runs FCS compliance. It was an eye-opening experience to hear what these central London estate agents did and didn't know about AML regulation and filing SARS. There have been fines. Last year, HMRC fined the online agency Purple Bricks £267,000, failing to comply with AML. The year before, they fined Countrywide Group £215,000. I mean, will this help reduce money laundering? To put that in context, the average estate agent fee is about 1.5% in the UK. So if you sell one £20 million mansion in Belgravia to some nefarious money launderer, you stand to make 300,000. So not a massive deterrent there. What's more, there is some concern that the pandemic has made due diligence harder by preventing agents meeting buyers face to face. While economic worries may have tempted some agents, to rush through sales without too much scrutiny. I spoke to a partner at a London law firm who told me that because of remote working, there's more of a chance of people to behave. There's more of a chance for people to behave fraudulently, and there's less of a chance that fraudulent behaviour is going to be discovered. Meanwhile, sales of London's trophy homes have gone up a lot. Luxury London pads are a tranche of properties beloved by overseas holders of illicit wealth because it's a valuable asset. It's well protected by the rule of law, ironically. It's got a certain cachet about it, and it's fun, right? You can go to Harrods and Annabelle's and the West End and all that. So, according to figures from Lonres, which tracks the luxury market, while sales of homes around about £1 million in prime central London have stayed pretty flat in the past year compared to the year before the pandemic, sales of homes priced above £5 million have increased by 21%. And this is while international travel restrictions have been prevented. International travel restrictions have prevented many overseas buyers from flying over to conduct viewings and such. So while estate agents have been getting to grips with these new regulations, there have been other changes too, most notably, as we've heard, about the Unexplained Wealth Orders. These are pretty high profile, but as we've also heard, they've only had limited success. Last June, the NCA was hit with a £1.5 million legal bill after a failed attempt to impose the orders on 3 London properties linked to the daughter and grandson of the former president of Kazakhstan. Several lawyers I've spoken to tell me that for the attention the UWOs receive, other legal tools have been more useful. As Anna was talking about earlier, in the same bill, the Criminal Finances Act of 2017, it's not the UWOs, but it's the account freezing and forfeiture orders, the AFOs, which have been more effective, and they can be pursued in the magistrates' court. So I do want to kind of race through the last little bit that I've got. Has any progress been made? I mean, the answer is perhaps. The key tool to money laundering property is via the use of offshore shell companies. As Roman was saying, I mean, currently we have about 42,000 properties in London owned by offshore companies, which is about 2,000 fewer than it was in 2015 when the Land Registry started publishing this. So is that evidence of the reduction of money laundering? Well, not exactly, because the use of opaque ownership is not just beneficial to money launderers, but people who want to obscure their wealth, either from the press or from shareholders or from the taxman, probably more importantly. I was speaking to a partner at a law firm who told me that 10 years ago, using an offshore company was the obvious advice to give when helping clients from around the world buy property in the UK, not for money laundering purposes, but for tax reasons, especially inheritance tax. Frankly, he said, you would have been negligent if you had not told them about it. So before April 2017, shares of offshore companies that held UK property were not subject to UK inheritance tax, charged at 40% of a person's estate above £325,000. Now they are. There's more. In 2013, the government introduced the annual tax on enveloped dwellings, or ATED. At the same time, the rate of stamp duty for corporates was increased, and there have been changes to capital gains tax. Now, that same partner who told me that you'd be negligent if you hadn't told people about it, then said, these days, no professional advisor in their right mind would steer any client into buying through any kind of corporate structure unless they were coming here to set up a rental business. And, this has caused a drop in demand of offshore ownership. That may have affected the property market. I mean, before those rules changed, between 2010 2013, London had the fastest growing prime property market of anywhere in the world. By the end of 2013, its prime homes were the most expensive in the world. A single square foot was priced at $3,995 by the estate agency Knight Frank. Compare that to Manhattan at that time, it was $3,101. Now, since 2014, after those rules were brought in pounds sterling, in sterling terms, the average cost of a house in prime central London has fallen 23%, and much more in other currencies. And there are lots of variables to that. It's not just about the ATED and offshore ownership. There's stamp duty being reformed. There's also currency changes and changes in the global economy. But if you're going to answer the question, how far have the UWOs or AML regulations in general affected the property market? I suppose you might say that it's helped reduce some tax avoidance, but other than that, without full transparency of who really owns property in the UK, it's really difficult to say. When I asked a money laundering expert this question last week, he took a sharp intake of breath. He said, money laundering has been going on the UK property market for decades. Some property bought with illicit funds have been family owned now for generations. So has it got better? Yes. Is it good? No. I think I better stop there. I think I may have gone wildly over time.
Thank you so much, Nathan. I think you did raise some quite worrying issues there, especially when it comes to what property agents can or are able to do when it comes to verifying who is behind the funds or property. So I think we can now go to try and address some of the questions that we have been receiving, and please keep sending those. So our first question is from Tom Main. He questions whether the UWOs can be successful against a foreign official who enjoys political favor at home, as they will appeal to their home enforcement agencies to rule their wealth is legal. And I suppose with the examples that we have seen with the Hajieva case and the Nazarbayeva case, that there are some sort of case studies that we could perhaps mention. Anna, what would you like to take that one?
Sure. Yes, it's a very good question. And I alluded to that when I said that perhaps the biggest hurdle that the enforcement authority faces is this need to satisfy the High Court that the known sources of their lawfully obtained income would have been insufficient to acquire the property. It raises two interesting issues, this question. Firstly, the issue of what kind of evidence the court will be prepared to look at, and what that exercise says about the court's willingness to take evidence into account for the purposes of a UWO challenge that it wouldn't necessarily consider in other circumstances. And depending on how the High Court determines future applications, it could, worst case scenario, lead to UWOs being undermined in their perceived legitimacy. And what I mean by that is this. So Zamira Hayebe, help me out here, the notorious first respondent of the first ever UWOs in the UK, she was subsequently the subject of an extradition request from Azerbaijan. She successfully resisted that request in the UK courts. Her extradition was refused by the UK on the basis that she was very unlikely to receive a fair trial if she was returned. And that kind of thought process hinged on the UK's view, the UK extradition court's view of the integrity of the Azerbaijani judicial system. Yet it was evidence from Azerbaijan that was relied on in the UWO proceedings. So there's a little bit of a dichotomy there. And the second issue that this question flags is the potential for UWOs to be politicized. And that's always been there. And clearly there have been too few cases so far for this to really be a credible risk, but it's there if, for example, law enforcement authorities start applying for UWOs against nationals of a particular jurisdiction or against particular categories of respondents, then that could also undermine the perceived legitimacy of UWOs as an investigative tool. But the flip side of that coin is obviously where UWOs are not applied for in circumstances where they ought perhaps to be applied for. And the only solution there is really civil society, Roman and others similarly situated, have the task of embarrassing effectively the law enforcement authorities into taking appropriate action, and then relying on the High Court to treat evidence presented by a friendly jurisdiction with skepticism, to avoid the kind of criticisms that I alluded to earlier.
Thank you so much, Anna. Roman, the next question is for you, but then if you also want to kind of follow up on what Anna said, please do so. So the question would be, is the UK still an attractive place for money launderers? And when it comes to perhaps people from Russia and the former Soviet Union, are we going to see another generation of oligarchs trying to hide their money elsewhere, particularly in the UK, or is anything changing? Are they going to are they disappearing? Is it a sort of a thing of the past, or will we see new approaches? And perhaps if you could also elaborate on the role of financial institution in preventing money laundering, that would also be quite interesting.
Right. Well, the only thing I could add to Anna's answer is that, I mean, everything is correct, and I'm not a specialist on the law side, but it's predictable that the most senior PEPs would be protected by their governments, and that UK courts will not probably challenge the rulings of national courts in relationship to these persons. But virtually myriads of smaller crooks could be weeded out by the Navalny's of the local of different countries. I've been in touch with many anti-corruption activists from Nigeria and India and Pakistan and so many other countries who are asking for this transparency because they suspect and they know where the money, who is taking the money abroad. They think they know where it's going, and all they need to link these events. So therefore, deputy governors and administrators of state funds, in regional administrators of funds, this lower layer of government employees embezzling funds, that is something that UWOs can be very useful again. In terms of the most recent events, I'm not sure how much of effect it had yet. Again, because a lot of this is perceived as pretty much toothless. You know, why have the unexplained wealth orders when you cannot prove who owns the property? You know, you can't serve it against a corporation. You can't force a corporation to admit who owns it. That's the biggest drawback. You suspect that that could be a foreign criminal, but the director in Panama is not going to tell you. So without it, it is very limited, has very limited appeal, and people understand it. So we have seen Russian oligarchs continuously coming to the UK, and you know, the Mintz family from Russia that moved from, well, I'm not sure from Russia exactly, directly, but people on paper trail leads through Malta, where they obtained the citizenship first and then traveled before Brexit and traveled and settled in the UK as EU citizens. And there are many other examples where the flow of money and people still continue. So from that perspective, it hasn't had a definitive effect yet. And again, we rely on the transparency rules to shake the ground here. In terms of financial institutions, but this is a financial institution's role, of course. You know, there's behind every transaction executed with participation of dirty money, there is an enabler, a banker, a lawyer, and an advisor, a financial advisor, an accountant, an estate agent, somebody who knows the true identity and true sources of the money. It cannot be, it's not possible that somebody arrives with a bag of money with unknown origin. Somebody behind it has definitive proof and knowledge of where the money is coming from. Somebody has reasonable grounds to suspect that this is not a legitimate proceeds of business. And to the extent that these people happen to be in the banks, they would need to reconsider their position. So from that perspective, again, transparency should add, it should solidify this regime of reporting and make sure that the reporting of money laundering is not just a crime in the penal code, but is actually enforced.
Thank you very much, Roman. Nathan, maybe you could also comment on the role that sort of the UK and London has played in international money laundering, and you did mention that there has been some effect on the sort of property market, and it's definitely very difficult to tell what has caused certain things, and especially in the context of the pandemic, because I suppose the market has been behaving differently because of that too. But if London is becoming less attractive for high net worth individuals, especially those whose funds have come from illegal activities, what does it mean for London's property market, and where else will these people go if not London, if not the UK? What are the other sort of hot jurisdictions when it comes to money laundering? And then what will happen to London? Is it going to be able to sustain the extremely high property prices, or what are your predictions?
Well, you raise a couple of interesting points there. I mean, one fascinating thing is that kind of before the pandemic, a couple of years ago, when people were looking at the London market and its downward trajectory in terms of prices and in terms of sales, people were asking this question, right? Is this the end of London as a kind of as an attractive place for high net worth individuals. Boris Johnson, when he was the mayor of London in about 2014, said that he wanted London to be to the billionaire what the jungles of Sumatra are to the orangutan, which is to say their natural habitat. Well, no, the answer is no, really. I mean, we've been thrown a huge curveball by the pandemic. And if you look at the numbers for luxury sales in London, as I touched on from Lonres, sales are up 20% on last year. I saw some numbers from Savills, which suggested that £5 million sales were at their highest level since 2014. So, something's going on. Now, whether or not things like Brexit and other political developments reduce the long-term attractiveness of London as a place to do business, that's interesting. It's kind of yet to be seen. We did see there was some numbers out this year which suggested that something like 800,000 overseas Londoners had gone back to their home country during the beginning of the pandemic. It's going to be a lot more difficult for them to come back now that laws have changed over who can come into the country now that the transition period has ended. But I think sort of kind of two things. London is certainly not the only show in town. If you want to go and if you've got illicit funds and you want to put them in the property market, and you can see huge increases in property markets in Canada, like Vancouver, Toronto, Sydney, the United States as well. In these places, it's not necessarily to say that these places have problems with money laundering, though I suspect they probably do, but that there is huge interest from high net worths in those cities. Were there to be a sustained sort of depreciation in London's cachet? I mean, I don't think it'd be a particularly bad thing, right? London has an incredibly unaffordable housing market, and if you can, if prices do come down, and that allows, I suppose, more kind of, we might call kind of domestically wealthy people to sort of trade up, then that frees up a lot of stock. Probably bad for luxury estate agents, but probably kind of minimal actually on the country as a whole, on the treasury and on the property market. Probably a kind of probably a net gain, really.
Thanks very much, Nathan. Now, Anna, you mentioned Brexit at the end of your presentation, and then didn't go into it any further. But would you like to perhaps comment on whether Brexit has changed anything, or whether things might start evolving in a different way because of Brexit?
Sure. It's in theory no change, but in practice there may be some changes. The topic of today's seminar is obviously focusing on the UK's property market, the UK's financial market, but UWOs and civil recovery proceedings can be brought in respect of property located outside of the UK. And one of the reasons why UWOs is attractive as an investigatory tool is because it can be directed to people outside the UK. And in that sense, the ability of the UK to secure the evidence that it needs in support of recovery from outside the UK is improved. But it all comes down to enforcement, because even if you successfully obtain a civil recovery order, then great. But how do you make sure that that property overseas is then actually recovered? And for that, you are entirely reliant on the overseas jurisdiction in question. And not many countries still today are prepared to act on that kind of mutual legal assistance request if they do not themselves have corresponding non-conviction based asset recovery powers in their own jurisdictions. So that's always going to be a hurdle for law enforcement. It's a particular hurdle post-Brexit because at least as far as EU member states are concerned, the UK is no longer part of these enhanced cooperation arrangements. So it can expect, at least in theory, a lower level of cooperation from its European neighbours. And also from an intelligence point of view, the UK is no longer in receipt of the same type of data that it used to have access to pre-Brexit. But conversely, and paradoxically perhaps, that actually increases the attractiveness of UWOs because of the difficulties that the UK might now experience with mutual legal assistance. The ability to get useful intelligence and information from individuals directly using UWOs could potentially be of much greater interest now, and the appetite could be greater as a result. But we'll have to look at the numbers and see if they rise, and then work out if we can attribute it to Brexit. I suspect it's going to be a bit of a leap, but those are my thoughts for what they're worth.
Thank you, Anna. Nathan and Roman, do you have any last comments? Because we are coming to the end of the webinar, but if you do want to add anything, whether on the issue of Brexit or any other topics that we have talked about today, please do so.
Well, just very, very briefly on the topic of Brexit, I'd like to sort of divert the audience to a piece written by a colleague of mine called Tom Burgess at the FT, who wrote a fantastic piece about global Britain and whether or not we'll do enough, that will do enough to clamp down on money laundering. There's all this talk about global Britain and London being kind of Singapore on Thames, Singapore on steroids, that kind of thing, and whether or not that does that kind of facilitates increased money laundering and corruption and tax evasion is something to really keep our eye on. But yeah, I would recommend that piece to read.
Sorry, Roman, any other points from you?
I'm sorry, I couldn't hear.
Sorry, I was on mute. Apologies.
All right. No, I agree with both and Nathan and Tom Burgess and his piece. However, you don't have to keep in mind that being out of the EU doesn't mean that the UK is out of money laundering regulation, and should it drop its standards below that's what's acceptable in the EU, especially MLD5, then obviously the UK financial institutions will lose any hope of getting passported in the EU, and that's something to keep in mind.
Thank you, Roman. We are at the end of the webinar, so thank you very much, everyone, for joining us today. And thank you, Nathan, Roman, and Anna, for your excellent presentations and answers to all these questions. It was very good to have this conversation today with you. If we didn't answer some of your questions, or if you have more questions and you would like to get in touch with any of our speakers, please do let me know, and we will try to make that happen. Our next webinar will be in June, and the topic will be about the risks related to global supply chains. So please do sign up. We will share more details about this next upcoming webinar on our social media and on our website. So thank you very much again, and have a good rest of the day.